Hello and welcome to today's coffee break briefing, or as is traditional, I think many of you have mince pies and mulled wine in front of you for the last one of the year. So it's a mince pie and mulled wine break briefing today. So the last one of the year, and today's session is on the Duomatic principle. There are 5 topics that I'm going to look at today. First of all, I'm going to start by looking at some old washing machines, obviously. Second one is I'm going to say why Duomatic, what's the relevance of this old case to modern company and insolvency law. And its relevance is actually down to a way of company members passing resolutions, making decisions in an informal way. So it follows on from last month's briefing, which was about members' general meetings and resolutions. So I will give a quick summary of the points that we looked at last month, and then from there I'll look at the Duomatic case itself and run through the facts of it so that we can see what happened and how and why it is still relevant. And then finally I'll give a summary of what the Duomatic principle is today and its relevance. So let's start by looking at some old washing machines. This is a Duomatic twin tub washing machine. So yes, they sold washing machines. They didn't manufacture them. They actually bought them from Holland. And in the 1950s, washing machines were becoming an important business sector. It was a vast growing market, people buying washing machines for the first time. And the market leader was a company called Duomatic, who imported these machines, twin tub washing machines, from Holland and sold them door to door on hire purchase. And 3 people left Duomatic and set up a competing business, which they called Duomatic. And they sold exactly the same washing machines, manufactured in the same place in Holland, just with a different name badge on them. And that business started in 1960, and in case you're wondering, the cost of a twin tub washing machine at that time was 52 guineas, which is £52 and 52 shillings, which is £54 and 60 pence in today's money. The business flourished, did very well for 2 or 3 years, but it was essentially a declining market that they had launched into, and by 1964 the business had failed and went into liquidation. And one of the reasons why the business failed was that better washing machines were available at a similar price, and this was the Hoover Keymatic, which was launched in 1961. And I actually, when I was an article clerk, I actually had a twin tub washing machine in the house that I shared with 2 or 3 students, which was okay, but it did give you electric shocks. The Hoover Keymatic that I replaced it with when I got my own flat as a newly qualified solicitor was very much a second-hand machine, much better than the twin tub. Didn't give me electric shocks, but it did have a tendency to flood the kitchen, which wasn't so great. But generally speaking, this was a better product, similar sort of price, and it knocked Duomatic's business for 6. So why is the Duomatic case one that's still important and relevant today? And the reason for it is we looked last month at how shareholders can make decisions either by a general meeting, a resolution passed in a general meeting, or by a written resolution. Well, the Duomatic principle, which emerged from this case in 1969, says that shareholders can, in some circumstances, make a binding decision in a less formal way. So that's what we're going to be looking at. And the key thing here, of course, is that we have a statutory separation of powers in corporate governance, that although the directors are in charge of the day-to-day management of the company, they're not all powerful, and there are some decisions that have to be made by the members. And it's the company's constitution and the Companies Act that set those decisions, which are reserved to the members, and the formalities for the members to make those decisions. And the Duomatic principle may validate decisions made by the members that would otherwise be irregular. So examples that you might come across, in particular, you may find that the Duomatic principle is at least argued by directors as giving them a defense to a misfeasance claim. They will say that the transaction that you are seeking to impugn is one that was in fact known about by the shareholders of the company and effectively approved by them and therefore validated by them. And the second example is that you might have circumstances where the Duomatic principle might validate an insolvency appointment if there were problems with the paperwork that had been signed at the time. So that's the relevance of Duomatic. Let's now review the issues that we looked at last month and just go a quick recap on those. So last month we looked at companies' resolutions and we started off by looking at this separation of power between directors and members in terms of corporate governance and company constitutional law. We looked at shareholder resolutions, the means by which members make decisions that are binding on the company. And we looked at the two alternative procedures for them to do that, meetings or written resolutions. And finally, we had a quick look at the situation that's increasingly common these days, where you have only one shareholder of a company and how the powers that are reserved to the members are exercised when there is only one person who is the shareholder of a company. So in terms of companies' constitutional law, the documents you need to look at to identify the company's constitution, what its terms are primarily the Companies Act and also the company's Articles of Association. Now, historically and currently, the company's own constitution, its Articles of Association, have very often been built upon statutory templates, which previously were called Table A and which are now called Model Articles. Model articles now are very, very good, and you find that a lot of companies simply adopt the statutory model articles without any modification at all. Previously, when it was Table A that companies were incorporated with, Table A was frequently amended, and you do get cases where companies will have bespoke articles which are not based upon Table A or model articles. And you also find that there can be contractual arrangements such as shareholder agreements and investor agreements, which effectively limit the rights of directors or members and are effectively also constitutional documents, and those can be relevant as well. One of the key concepts of company law is this idea of separation of powers between the directors, who are the executive, who represent the company, and the members, who are one step removed. Members can also be described as shareholders or contributories, depending upon circumstances and context. The directors are the agents of the company. They have the power to do things in the name of the company and which are binding on the company. The shareholders, the members, do not have that power. They have more of a supervisory role. There are certain decisions that are reserved to them and which they will make in general meetings. Looking at decisions that shareholders make themselves, members of a company make decisions by passing resolutions, and there are broadly two types of resolution. There's ordinary resolutions which need only a simple majority to pass them, and there are special resolutions which need a 75% majority to pass them. And resolutions can be passed at a meeting of the members. It's for the board of directors to call a meeting of the members if they need a resolution to be passed. And the main business at a general meeting of members is likely to be the passing of resolutions that the board need to have passed because they're decisions that the directors themselves are not able to make. The alternative way for members to make decisions is to pass a written resolution, and a written resolution has exactly the same legal effect as a resolution that's passed at a formal meeting of the members. And there are procedures that have to be followed to pass a valid written resolution. The Companies Act helpfully says that if there are any irregularities in following that procedure, that won't invalidate the resolution that's passed. The courts have been a little less sympathetic, and they've said that in some cases the procedural irregularities are such that effectively you haven't passed a decision at all, and therefore the resolution is not valid. So you can't rely on the statutory provision in the Companies Act as a get out of jail free card to validate a written resolution which has got some irregularities to it. And to pass a written resolution, you need the same majority of the members as a whole as it would take to pass a resolution at a general meeting. So to pass a special resolution at a general meeting, you need 75% of those at the meeting. To pass a written resolution as a special resolution, you need 75% of all of the shareholders who are eligible to vote. And for an ordinary resolution, it's 50% of the shareholders eligible to vote. Written resolutions, very convenient and can be very quick. The final thing that we looked at last month was sole members, companies that have got only one member. And you still have the same separation of powers, that there are some decisions that are reserved to the single shareholder of the company and which cannot be taken by the directors. You may have the same person as director and sole member of the company. If they make a decision in their capacity as member, then that is regarded as having the same effect as a resolution passed at a general meeting or as a written resolution. They will need to keep a written record of the decision that they have made in that way, so that there is a record in the company's records of it. So that's what we looked at last month. This month we're now going to look at Duomatic, and that has effectively allowed another way for members to make decisions other than at formal meetings of the members and other than by using a written resolution process. So Duomatic, it was a case decided in 1969. As I said at the start, the business was set up beginning of 1960 and did pretty well for the first 2 or 3 years, but it was launched into a declining market where there were better products on sale, where there were other competitors who were setting up. And it was set up by 3 directors, 3 shareholders originally, and one of them, Mr. Hanley, left as both director and shareholder in the spring of 1963, 3 years after the company was founded. The law report, Duomatic, is not kind to Mr. Hanley. It appears that he was drunk, he was lazy, he was rude, he was indiscreet, he was argumentative. He was not much of an asset to the board of directors. So the other 2 directors, shareholders, persuaded him to leave. By the following spring, the business was clearly in decline. One major investor in the business was a hire purchase company, and this actually gives quite a good insight as to who was making money from selling twin tub washing machines. Duomatic were making a lot of money, but also the hire purchase company that was funding the purchase of the machines was also making a lot of money. Anyway, the hire purchase company that was an investor asked for Mr. Wood to join the board of the company in spring of 1964 to try and turn its fortunes round. And that summer, new investors came on board. The number of shareholders, originally there had been 3. When Mr. Hanley left, the shareholders went down to 2. Summer of 1964, there were then 7 shareholders brought in, so a total of 7 shareholders of the company. It wasn't enough to arrest the decline in the fortunes of the business, and it went into liquidation that autumn. And 18 months later, we had claims brought by the liquidator against the directors. And the essence of the claims were that the directors had drawn remuneration from the company unlawfully. And the main argument was that the Articles of Association of the company required the shareholders of the company to approve the remuneration that was paid to directors. This was set by the Articles of Association of the company. The articles adopted the 1948 version of Table A without any significant modifications. This has now changed in the modern model articles that companies use, and it now needs only only needs director approval and not shareholder approval for directors' remuneration. But at that time, it did need shareholder approval if your articles were based on Table A at that time. There was no formal members' resolution. There had never been a decision made to approve the directors' remuneration, and it therefore appeared, looking at the company's records, that the directors had taken money to which they had no legal entitlement, and there were therefore claims against the directors who had received that money to pay it back, and there were claims against the directors as a whole for misfeasance in having approved payments that were unlawful. I'll just tell you a bit more about who the shareholders were at the relevant time. So after Mr. Hanley left, you had 2 ordinary shareholders, Mr. Elvins, who had 98 shares, and Mr. East, who had the remaining 2 shares. In addition to the ordinary shares, there were also a large number, tens of thousands, of non-voting redeemable preference shares. And just as a reminder of what non-voting redeemable preference shares are, as the name suggests, these are shares where the holders of the shares get no vote at general meetings. And in fact, the terms on which these shares had been issued meant that the preference shareholders were not entitled to receive notice of general meetings, and they weren't entitled to attend general meetings. So they really had no say at all in the sorts of decisions that shareholders would normally take. They were redeemable shares because the shareholders would be entitled in some circumstances to sell the shares back to the company and get back the money that they had paid for them in the first place. And they were preference shares because the dividend paid on those shares was paid in priority to any dividend to the ordinary shares. Now, the way that preference shares normally work is that they carry a rate of interest, say 3.5% or something like that. So in many ways, these non-voting redeemable preference shares were more like a loan than equity, but because they were share capital, they did appear on the balance sheet as equity capital in the company, and the company would be obliged to pay 3.5% or whatever the coupon was on these shares as a dividend every year when profits allowed, and before they paid any dividend to the ordinary shareholders. So that was April 1964, following Mr. Hanley's departure. We had these 2 ordinary shareholders and a lot of, well, 1 preference shareholder, but it was essentially the ordinary shareholders who were the only ones entitled to attend general meetings and vote on resolutions at general meetings. That summer, 1964, the number of ordinary shareholders went up from 2 to 7. The preference shareholding stayed just the same as it had been before. That didn't change. The liquidator brought 3 claims against the directors. The first claim was the biggest. This was for remuneration that the directors had taken before the end of April 1964. And you'll remember that the Articles of Association said that this remuneration had to be approved by shareholders to be legitimate. Now, as it turned out, in 1963, 1964, companies' statutory accounts filed at Companies House were rather more informative than most companies' accounts are these days, and therefore the directors' remuneration had been written into the statutory accounts, and the statutory accounts had been signed off by 2 directors to approve them, and the 2 directors who had signed off the statutory accounts had been Mr. Elvin and Mr. East, who by happy coincidence held all of the voting shares, the ordinary shares of the company. And the court decided that when they signed the accounts to approve them as directors, that also sufficed to show that they as individuals who owned all of the voting shares of the company effectively had approved them as shareholders as well, despite the fact there was no general meeting called, there was no resolution passed, there was no record in the company's records of resolutions of a resolution to that effect having been passed and approved. The preference shareholders could be disregarded for this purpose because they weren't entitled to attend general meetings and they had no vote. All that you needed to comply with the Articles of Association was the approval of the ordinary shareholders. And therefore, this remuneration to the directors was regarded as legitimate, and the liquidator lost claim number 1. Claim number 2 was against Mr. Hanley's loss of office. You'll remember Mr. Hanley was drunk, lazy, indiscreet, argumentative. There were reasons why they wanted to get rid of him. And a payment for loss of office paid to a director required approval by the company's shareholders and disclosure to the company's shareholders. And that wasn't from the Articles of Association, that was from the Companies Act. So although this payment had been noted in the company's accounts, that was insufficient to form disclosure and approval to the shareholders, because for these purposes, the preference shareholders needed to be included. They needed to have this payment disclosed to them, and there was no evidence that the accounts had actually been disclosed to the preference shareholders or that they had been told about this payment for loss of office. So this payment for loss of office therefore did not comply with the statutory requirements and looked like an unlawful payment. The directors then said, can we be exonerated for this payment? And there was a provision in the Companies Act, there's always been a provision in the Companies Act, it's currently section 1157, I think, of the 2006 Act, which says that if you've got a claim against the directors and they've acted honestly and reasonably, then the court can relieve the directors from their legal liability for breach of duty in a case like that. This might be a useful topic to cover at a future coffee break briefing, possibly section 1157 of the Companies Act. But in this particular case, what the court said is the board of directors had failed to take legal advice before deciding to pay Mr. Hanley £4,000. And to put this into context, £4,000 in 1963 is equivalent to about £75,000 in today's value of money. But in the context where an average house in the UK would cost between £3,500 to buy, so that's about £60,000 would buy you a house effectively, and where he was paid £75,000 for loss of office. So it was a significant payment to him. And the judge said, well, this was before the days of employment protection legislation. They said, you could have sacked him as an employee, paid him 1 month's notice, and you could have removed him as a shareholder by passing a shareholders' resolution to do that, and he was a minority shareholder, so he couldn't have stopped that resolution from being passed. And having done that, he then would not be able to sell his shares to anybody that the other 2 directors didn't like, because that's what the Articles of Association said, that although shares could be sold the directors would have the ability to refuse the transfer of shares to somebody that they did not approve of. Therefore, the courts thought that it was not reasonable for the board to have failed to take legal advice before deciding to pay such a substantial amount for loss of office to Mr. Hanley. And they did not relieve the directors from liability for this claim, claim number 2. So this wasn't as big as claim number 2, but this one is chalked up as a win to the liquidator. Third one, claim number 3. This was Mr. West. And you remember Mr. West was the representative of the hire purchase company. He was brought in the spring of 1964 as the business was in decline, where the hire purchase company, as a significant investor, was trying to turn around the business. He was paid a salary, and the arrangement for him was that he had agreed with the directors that he would be paid a salary of £60 a month. As it turned out, he actually received rather more than that, because, as the other directors did, he took money out of the company as and when he needed it. Now, the payment to him was not disclosed in the accounts that were signed off by directors who happened to be all of the ordinary shareholders. So the payments to Mr. West were not approved, even informally, by the members of the company. And so, at face value, these payments were not legitimate. They did not have shareholder approval. They were not lawful. The court decided that because there was a written agreement for him to receive £60 a month, that figure was an honest and reasonable amount for him to receive. And therefore, the claim for the payment to him at £60 a month would not be allowed. But to the extent that he'd received more than that, that claim would be allowed and would succeed. So that was a partial success for the liquidator. So overall, liquidator didn't get what he was asking for, but he got some of what he was asking for, and the court also awarded him his legal costs. So it was probably a decent result, I would imagine. So that's what Duomatic was all about, and particularly with claim number 1, that's a good example, as you would expect from the case that bears the name of Duomatic, of how the Duomatic principle works in practice. So let's just summarize now what the Duomatic principle is all about. And essentially, it can be described as where you've got a unanimous decision of all of the shareholders, that is the same, has the same legal effect as a resolution passed by the members of the company at a general meeting. And it doesn't matter how informal that decision is, how sparsely recorded it is. There's obviously issues of evidence and proof. The directors have to show that that decision was made, did exist. But if they can do that, it is treated as a valid resolution of the company's members. So it means that if the shareholders make a unanimous decision, that's treated as a valid resolution, even if it's a meeting that would otherwise be defective, or even if there is no meeting at all of the members. And they don't all have to sign the document at the same time. They don't even need a written document for the Duomatic principle to apply. It can be very, very informal. And so circumstances when you might be able to use the Duomatic principle, I've got one here, which is an emergency centre bind, for example. I mean, if you can imagine yourself, it's 4 o'clock on a Friday afternoon, and you really do need to get yourself appointed as liquidator before close of business to secure the assets of the company. You've got all of the directors on a Teams meeting with you. They are all of the shareholders. You could get them to agree there and then that they are passing a unanimous resolution to wind up the company and to appoint you as liquidator, and that would be regarded as an effective decision on the Duomatic principle. There are limits on how far Duomatic can go. You can't use the Duomatic principle to remove directors or auditors, even if you've got this unanimity of shareholders, and that's because there is a procedure to follow under the Companies Act that involves notices being given to the directors or auditors who are being removed. And you can't use Duomatic to approve a transaction while the company is insolvent, because of course the interests of the company are normally aligned with those of the shareholders, the members, but if the company is insolvent, then its interests are aligned with those of its creditors instead. And that's a spin on Duomatic that has evolved in the years since the Duomatic decision itself. So with that, that's a summary of Duomatic. I've covered the topics I wanted to in slightly more than half an hour. And I've now got some dates for your diary. All of these are dates of events that I'm involved in, apart from the R3 Personal Insolvency Forum, where I am going to it as a delegate, but no more than that. So the first coffee break briefing of next year, and I'll take this opportunity to wish you all the very best for the Christmas break and the new year, and hope to see you again on the 12th of January, when the topic is going to be an update on the reforms to Companies House. Some of those came into effect towards the end of last month. In particular, the requirement for directors to have their identity verified. So I'll be looking at those changes and the practical implications of them. If you're local, we've got the R3 regional meeting in the evening on the 12th of February, which is at the Empress of Blandings, which is a lovely pub just on the edge of the New Forest. And I hope you'll be able to come to that. There's the R3 Southern Forum, where I am involved in helping to put the programme of that together, in London on the 18th of March. Please do put the details of that in your diary. Please do make a note of it, and please do book it as soon as the spaces become available to be booked. There are the dates of the SESCA Insolvency Seminars and Conference next year. There are seminars at Denby's on the 21st of May and the 15th of October, and the two-day insolvency conference on the 10th and 11th of September in Reading. And most important of all, on Friday the 5th of June is Fretton's 4th annual insolvency conference, which is being held in the New Forest. That's an all-day conference, and I do hope that as many of you as are able to will come along to that. So anyway, thank you all very much for attending this morning. Thank you very much for your support for the coffee break briefings during the year. Hope you have a great Christmas and a great time at New Year, and see you again sometime in 2026, if not before. Thank you and goodbye.